Welcome to Queen City News Plus. We got order in the court today. We got anchor Brian Blakely with you.
Chief Legal Analyst Khalif Rhodes. How you doing, Brian?
Oh, I'm good today. Good today on a Monday. We got a lot of stuff to talk about. First off, we got a couple of Supreme Court cases, and then there was that wild shoot 'em up at a pool party that we're going to talk about as our last segment. But let's start here, Khalif, first with the Supreme Court hearing a couple of arguments that could have some big ramifications going forward when those decisions come down maybe later this summer. The first one has to do with the mail-in ballots.
Mail-in ballots, this is high stakes. You're talking about 31% or roughly 48 million voters cast their ballots in the 2024 general election. That's a lot of folks. That's 1/3 of the nearly American voters cast their votes with mail-in ballots. So
the Supreme Court, they seem skeptical in their arguments. They're hearing today.
Skeptical is a polite way of saying
about having the grace period for those mail-in ballots after Election Day. That's the big key here.
Well, the key thing is a couple concerns. So first of all, do we have Election Day, or as Justice Alito said, or is it now turning into election month, right? That's his argument, because now we have early voting, and I'll touch on the early voting portion, which is before Election Day, and I'll talk about the counting of the ballots, which is after Election Day. This case is in Mississippi, and ironically, both of our cases come out of Mississippi. I don't think that was intentional. That's just the way the docket ran today. But the case boils down to, is this a case of election mechanics, or is this about federalism? 1845, Congress decided that there will be one election day throughout the country to avoid states having election days on different days. So on that specific day, we can know the final end of the result, and that would be it for these, federal elections. So what the Mississippi Solicitor General is saying is that Congress, when they implemented an election day, never considered, and therefore never prohibited post-election day ballot receipts or ballot counting. And so translating that into everyday English as opposed to legalese, if Congress doesn't preempt it, states retain authority. That's our Constitution. If it says that if Congress doesn't explicitly tell you to do something, either do this or do that, then it goes to the states. And now this is a federalist question as opposed to an election question.
And that is the big thing here, because states have their own way of doing things. It says, like we've seen with North Carolina, mail-in ballots from military voters overseas come in weeks later, and they have to wait to be counted.
That's why you have 14 states that have this, and you got 17 states that have something similar to this. Yeah, that's 31 states in Washington, D.C. that deal with this, but then you still have the other states that don't. So what they're arguing in the Mississippi's Solicitor General Stewart is saying that this is something that historically is on our side, that we've had this argument in this way of doing it for a number of years, because Congress hasn't explicitly indicated how we should do this. This is a states' right argument. The irony of this entire argument is that you have the common players, right? You got the folks that are going to be on the conservative side of the docket, which is the Alitos and the Gorsuch and the Clarence Thomas. You have the folks on the more liberal-leaning side with the Sotomayor, the Kagans, and the Jackson. Their roles have been reversed in this argument. When you look at what happened in the Dobbs decision, all of the argument was that there is no constitutional rights to abortion. This is from the conservative side. We're going to send it to the states because the states are more properly positioned to deal with this. Today, Jackson, Kagan, and Sotomayor are making that argument. They're saying federal government should not be deciding this, that states should be deciding this because Congress never anticipated in or is silent on it. She even brought up the most recent law Jackson did that Congress passed, the Making America Vote Act. When talking about that, she said Congress has opportunity to pass something to address this, and they haven't. So she's saying because this hasn't been addressed by Congress, this is again a federalist question, and it should be done by the states. The last point I'll make, Brian, is that, and this is the argument that Jackson, when they were questioning Clement, who was making a number of the arguments for the Libertarian Party, she's saying most of your arguments are against are in favor of election day, everything taking place,
Hmm.
right? Voting and counting. She says, well, if you're making the arguments, how come you're not saying that we can still have early voting? Because if your argument is that we should only be doing everything on the same day, and he conceded that there are some folks within this case, because there were other attorneys arguing for the Republican National Committee that were arguing, yeah, we shouldn't have early voting. He wasn't agreeing with that. So they were saying, well, how do you square that for us if you're saying that everything should happen on the same day, but early voting?
And also, the the justices here seem to be one leaning toward this argument that the mail-in ballots shouldn't count after election day. If that were to happen,
Yeah,
if
yeah,
that
yeah.
decision were to come down in the summer, how long would that soon would that be implemented going into the midterms, and how important that would be, and how much of an upset and a disruption that would be
Well,
going into the midterms, if there would be any?
the only leaning we've seen today is 3 and 3. We got 3 on the one side and 3 on the other. We still got 2 other folks that haven't told us where they're leaning at all. We got again, I mean, I think there's 3 other folks that haven't fully told us where they are, but if it really comes down to it, it's 2. It's Barrett and it's our Chief Justice. Those 2, if they're able to tip their hat, I mean, and today oral arguments are over, so there will be no tipping of the hat. We won't find out until July when everyone else, but it was clear from listening to oral arguments that only 3 people on the one side and 3 people on the other side have made up their mind. And so with those numbers, we won't have a decision.
But if that decision were to come down where the mail-in ballots would not be counted after election day, when would that be implemented? Would it have an impact right away on the midterm election?
Decision, I think, anticipating in July. And yes, it would have an impact on the midterm elections because 31 states that have laws that are similar to this, North Carolina, South Carolina, and other states that watch our programs would be impacted immensely. This is, like I mentioned before, 1 in 3 voters that currently vote in the election, in the last presidential election, wouldn't be able to do it unless they could guarantee that it got there in place. So what is the secondary effect? If I put my ballot in the mail and I can't guarantee that it's going to get there by that day, I'm less likely to do that and more likely to go in person and vote. And that's what the discussion talked about as well today, that what secondary effects will happen when you do something like this. A number of folks made an argument about it's too drastic, it's too close to an election. That argument was shot down. But there was argument about confusion and likelihood to confuse voters because historically this is how it's been done, and now changing it. I'm again not a fortune teller, but listening to Justice Barrett, she is truly a swing vote. Sometimes you're like they're being coy about it and they're asking questions, and you can kind of figure out. I could not make any determination on which way she would go, and yeah, and our Chief Justice Roberts was definitely he wasn't silent, but he was for sure not speaking like the other 6. They had tons of questions. There was a lot of support because the South Carolina, Mississippi Solicitor General, his argument started off weak. If I'm being honest, he had a lot of pauses and a lot of struggling to get his argument out. Oftentimes, when a person is doing that, his supporters on the bench will help him. Will throw him a lifeline. They'll make a hypothetical, and then he'll get an opportunity to say, "Yeah, like that, Your Honor."
Right?
That happened a lot today. Jackson saved him. Sotomayor saved him. Kagan saved him. And then, but his closing was dynamic. So started off shaky, got hammered in the middle, but closed really strong.
And as you always say, start strong, have a good middle, and then finish strong too.
He definitely didn't take my advice in the beginning, but
Right.
his closing was something that was amazing. But Clement is probably one of the best that was representing the libertarian side that does this. I mean, so
Yeah,
his
his comment
argument
was, "This is the reddest of red herrings."
his arguments literally, some folks can argue paragraphs, sentences. He was arguing paragraphs off the top of the head, and they were just letting him go. When they let you go like that, that means you're controlling the room.
All right.
He was.
Sounds good. We're going to let this one go on, and we'll find out what this results are going to be from the Supreme Court coming up in the summer, maybe in June or July. Another one from the Supreme Court. We're talking about same thing from Mississippi, but a different case involving a street preacher. And we're going to have much more on that one coming up after the break. You're watching Queen City News Plus, Order in the Court with Khalif and Brian. Welcome back to Order in the Court. Cleve and Brian here. You're talking about second topic today, Cleve, is the Supreme Court, and it's about Mississippi again, but it's about a street preacher's First Amendment charge or challenge moving forward here about what happened when he was put into a place where he was trying to preach his message, but he felt like he was pigeonholed into an area because of a law, a local ordinance.
I think your breakdown of that is crystal clear. So you don't get uniformity with the Supreme Court often. You did here 9-0 decision to allowing his case to move forward. And so while this is a First Amendment case and ultimately it will be decided on the First Amendment grounds, until we get to court, none of that matters. And so this case was, should he be able to get an opportunity to even have his case go to court? There's a case called Heck v. Humphreys that basically says if you are convicted under a law, then you're going to be barred from bringing and challenging that law at some later time. Well, this individual pled no contest to this law, and what he's asking for is outside the bounds of Humphrey, and that's what the court said, that he's asking for forward-looking relief, injunction, to stop this from happening again. He's not asking for retroactive. He's not saying, hey, I know I was convicted of this, no pled, no contest, and I don't think this law should have been in place as it applies to me. He's saying, as it applies to everyone going forward, this law is unconstitutional. They're saying because of that, in the manner in which he crafted his argument, that he can go forward. The lower court, the Court of Appeals for the Fifth Circuit, didn't agree with that argument. That's how we got to the Supreme Court. They said his case was barred through qualified immunity, and because it was barred through qualified immunity, he couldn't bring a claim against the local individuals there that brought that ordinance. And so he said, I'll take it all the way to the Supreme Court, which is what he should do in scenarios like this.
How did the justices react to the arguments today in court?
This one was again less arguments, more procedural than anything. Different than that last case where you're getting a lot of fireworks and back and forth. This is an order that's coming right from the court, unanimous decision, and so they're going to say a couple of things. That Heck case that I talked about before, Heck v. Humphreys, does not apply, and they'll walk through why it doesn't apply. Looking back, the conduct involved in a prior conviction and offering contradictory proof, it allows this case to go forward specifically because it's forward facing. And why is this important? In the lower courts, in the Court of Appeals, this individual's case was kicked for motion to dismiss, saying that he lacked the ability to bring this case, and the lower courts didn't even allow it to go forward. Now he'll be able to argue a couple things. You mentioned before that they had a designated location for him to preach, but I even go back a step further. This guy's on the street. He's out there preaching in his town. Local law enforcement take issue with street preachers, and so they petition the municipality to create an ordinance. They create this ordinance. He goes out there, and they say, hey, here's a preaching zone. This is where you have to be able to do this activity. He thought that it was unfair.
Nobody could hear him in that designated protest
So
area.
he walked around to the front of the building,
Mm-hmm.
i.e. gets arrested. Now, when you talk about First Amendment, I say it all the time. The government can chill your speech in public places, but it has to be narrowly tailored and in a compelling public interest, right? That's strict scrutiny. There are other lower standards, but in regards to First Amendment speech, that's the normal standard. Compelling public interest and narrowly tailored. That's the argument that the court's going to have to make when they go through this analysis is your ordinance narrowly tailored? Do you have a compelling public interest? Well, what is it? They'll be arguing it's public safety. He'll be saying that your public safety, you'll have to point to some history of violence connected to this speech. But then also, you'll have to be able to say, is your interest greater than the rights of you, or than the harm that will come from you trampling on my First Amendment protected speech? I think that this is called something called time, place, and manner, where, yeah, we're not telling you that you can't talk. We're not being content specific. We're not saying we don't want you to talk about, Jesus. What we are saying is we don't want you to do it right here. Historically, time, place, and manner arguments have been held up in court. However, they must be narrowly tailored, compelling public interest. I think that this one is going to be hard for the state of Mississippi to win because there's not going to be evidence of historical connection of violence or some type of whatever their compelling public interest that will be enough to overcome his argument of trampling on and infringing on his First Amendment.
And this could affect the local ordinance here in Charlotte, possibly.
Yeah, I mean, these types of things. Now, the court could limit it and say this is only specific to his type of case into Mississippi, and that's it, right? Because remember, the Supreme Court is not even going to hear this right now. They're saying you can move forward in federal court, so it's going to go all the way back to the district court in Mississippi. If it goes to the Fifth Circuit Court of Appeals, still would have a direct impact on us here. But if he appealed, say if he lost there and appealed it to the Supreme Court, and then the Supreme Court ruled in his favor there, yes, it would ultimately affect us. But this didn't kill his case. And that's the best part, because most of the cases that go in front of the Supreme Court aren't granted cert for them to hear it. Second of all, if your case makes it this way, you got to have a lot of resources. You got to be able to go to the Court of Appeals. You got to be able to go to U.S. District Court. You got to be able to have a brief in front of the and a petition in front of the United States Supreme Court. Now, that's cheap. So for him to make it this far, he has the resource to continue to fight
Keep
this battle.
fighting,
That's
yeah.
good.
Coming up, we got our last topic here. Deadly pool shooting that was being rented out for a pool party. Lots of issues, a lot of legality problems with this, and we're going to break it all down coming up. You're watching Khalif and Brian on Order in the Court. We'll be right back. Welcome back to Order in the Court. Khalif and Brian here as our last segment here. Deadly shooting at a crowded pool party here over the weekend, Sunday night here in North Charlotte off of Hucks Road. It was a pool that was rented out. And this has been an issue for a lot of folks here recently. This turned deadly, though, as this pool party rented out in North Charlotte. They said there were some 200 plus people there.
Yeah.
200 plus capacity on the pool. There was actually some 400 is what they believe
Right,
there. So
right.
there's a lot of issues to work out from the rental aspects of this.
Yes.
Who's liable here for the people they rented it from, people that were renting a house?
Yes,
And-
you hit on a couple things, Brian. This was a renter basically subleasing the pool short term, right? So this person's in the property and they are a renter. And then all of a sudden they rent it out using an app similar to Airbnb.
Swimply app.
Called
Yes.
Simply, but that's all same type of thing where you go on there looking for a location and you can rent short term from another individual. And that's what occurred here. You mentioned it before in the intro. We've had issues here in the area with short term rentals. We've had issues in the area in the past with pool rental issues as well. This is a combination of both. So you ask about liability, right? Who can be held responsible? First of all, it's going to be, well, what does the document say? So who are you renting it from and who are you leasing it from? I think would be the first thing. So initially it's going to be that woman that's the lease holder with the building. She'd be accountable first, right? Because she
Does that come under the Swimply app with their document?
and that's what I say. It depends on what the document says.
Mhm.
So if there's some type of language in there that covers and talks about like liability,
Mhm.
then yeah, it would be her in the app is where I would look first. I'd say you knew or should have known that these types of things were reasonably foreseeable. That's the claim I'm bringing against the application creator, the developer, the owner of the app. I'm bringing against her for as well for the liability or potential. Now she'll have a number of defenses. First of all, you rented this property, this pool for me, with the expectation of 200 people being there, and you had 500 folks being there. Red flag. The other red flag would be that you had your own security that's handing out bands and wristband bracelets to individuals that are coming into it like it's a club. Those are the types of things that now you've assumed some of this risk that could have been there. But then the other thing is, as a homeowner or as a lessee of the building, because she's not the homeowner, what duty do you owe to a guest? What duty do you owe to an invited guest? What duty do you owe to a trespasser? They're all in different categories, right? The person that rented the location from her would have been an invitee. You've given this person an opportunity to be on the property. They're invited to the property. They have a right to be there. So the individual that got injured would have a claim against, I should say, multiple individuals the person that rented the property, the person that's the ultimate renter of the property in the app.
You mentioned there the homeowner themselves. Are they liable in any way here?
I think they're probably the furthest liable, but then it's going to be because I saw that a number of neighbors said these type of parties have been happening there for a number of months, massive parties with DJs and things like that. So then the question would be, did you know or should have known that this was happening as well? I think it's going to be harder to hold them accountable and liable for anything that happened at this location because they're so far disconnected. I mean, they own it, someone's renting it, a person rented it from the renter through an app. There's like
But in
5
civil
degrees.
suits, you have a wide blanket there.
Oh, you're throwing not a wide blanket, but a wide net because you're trying to catch everybody. Remember, this is a wrongful death. This person died. 5 individuals were shot. So because someone was
20-year-old
killed,
Richard Thomas is who
right,
died. And yes,
because this individual died, you're now saying that the estate's going to try to find a way to be made whole. Like this is the worst scenario that you could have. It's a tort, negligence, duty, breach, causation, and damages. Death is the worst damages that you could have. But it's, do you owe a duty? Have you breached that duty? And then are you the proximate cause? But for you renting this location with this person that died. And that's going to be the standard argument in a nutshell. That but for argument is going to be hard because there are going to be so many other variables. I can rent this property out 500 times in a row and something like this will not happen, right? And so that's that but for. And then did they contribute to that? Remember, our state's a contributory negligence states. So even if the victim had contributed to this in any way, bringing a claim would be barred in our state because they would have been contributing to their own scenario happening. So I could say that this case is going to be extremely complicated if there is a claim brought. But because we're a litigious society, I say that all the time, I suspect that there would be. And because there's an app connected to this, they're probably going to be the first line of defense. I'd say that this is kind of like the Uber incidents that we had happen a few years ago when people were getting into the wrong cars and and while Uber didn't do the wrong to the people that got hurt in these cars, what did occur is that Uber was on the hook because it was reasonably foreseeable that something could happen. So while I think the renter, person that's renting the property from the homeowner, could be on the hook for the negligence aspect of it, I think that the app could be on the hook for that reasonably foreseeable aspect. So you have 2 different claims and you just list them all and have a different argument for both.
Well, it's one we're going to have to leave it right there right now. We're following this much more on Queen City News today and throughout the rest of this week and exactly what happened with the police investigation and what that app, what their comments are, their statements coming out about this. All right, that's going to wrap it up here for Order in the Court. Khalif and Brian, we appreciate you all joining us and hope you have a great week.
Queen City News Plus. Just search Queen City News on your smart TV's app store.